Good afternoon. My name is Alina Shaltsova. I am an immigration attorney from Brooklyn, New York. In today's video, I would like to tell you about deferred action status. You might have, maybe yes, maybe no, maybe you heard the news about USCIS first abolishing deferred action programs for non-military members and then restoring them. What is deferred action status? Deferred action is a form of a government discretion that is given to individual who does not qualify actually for any status under the law. For example, consider a person who overstayed his tourist status, but now he or she is in the United States and is in need of medical treatment. This person is most likely will not be able to extend their status if the status already expired. So what this person can do? Does she or he have to leave the United States? Well, perhaps, or maybe not, because there is deferred action. Deferred action can be applied for at the local USCIS office. Typically, a person would walk in and hand his or her application at the front desk. The person would have to present proof that he or she was in legal status in the United States, which is expired. The person will have to also bring his or her passport, proof of identity, and most importantly, the person will have to show that there is a need of ongoing medical treatment. Usually, it will be shown in a form of medical records from a person's treating doctor who would attest as to the treating plan, various complications that were in the past, may happen in the future, and if the similar treatment is available in a person's country of origin. If it works, and if USCIS agrees with the person, then deferred action will be granted for 2 years, not only to the person, him or herself, but also to the immediate relatives, meaning children under 21 years old and spouses. The person who is granted deferred action may also apply for employment authorization, and so would be his or her family members. So it's a great solution for some people who are in need of medical treatment. But it's not the only case when a deferred action can be granted. Deferred action may also be granted to those who cannot return to their country of origin because, for example, a serious natural disaster happened there, an earthquake, hurricane, things like that. Deferred action also can be granted by ICE in a different form, not in the form of a 2-year-old status. But sometimes people think that deferred action can be granted only to those who are in removal proceedings. This is not the case. For decades, USCIS has been granting deferral action as well, affirmatively, meaning the person does not have to be in removal proceedings. Also, you could have heard about a special deferred action for childhood arrivals. That is different, DACA. For that, there is a centralized nationwide filing. There are instructions printed and published on the USCIS website. There are strict rules and there is application fee. For deferred action that I just talked to you about, there is no application fee and there is no formal application. You will just need to submit your request in writing and attach proof of why you would like to stay in the United States. And you can read more about deferred action on our website, www.shaltsova.com. Thank you.